Have you ever wondered who can see your private health information, or whether your medical history is truly confidential? It is a common concern for many, especially when dealing with sensitive health matters or when you think about potential legal situations. Generally, no, medical records cannot be released without your specific authorization. The Health Insurance Portability and Accountability Act, widely known as HIPAA, provides strong protections for your health information. This means that in most situations, your explicit permission is required before your medical records can be shared with others outside of routine care. The core reason behind this protection is your right to privacy and control over your personal health information. HIPAA establishes national standards to protect sensitive patient data, identifying specific entities, like healthcare providers, health plans, and healthcare clearinghouses, as what are called covered entities. These covered entities are legally bound to safeguard your medical records and can only disclose them under specific conditions. While your authorization is usually needed, HIPAA does permit disclosure without your explicit consent in several crucial situations. These include disclosures for your own treatment, payment for services, and certain healthcare operations, often referred to as TPO. Additionally, records can be released for public health activities, law enforcement purposes with a proper legal process like a subpoena or court order, workers' compensation claims, and in emergencies to prevent a serious threat to health or safety. However, even in these exceptions, there are rules to limit how much information can be shared, typically following the minimum necessary standard. To exercise your rights, you can provide a specific written authorization from that clearly states what information can be released, to whom, for what purpose, and for how long. You also have the right to revoke this authorization at any time, in writing. Understanding these processes empowers you to actively manage who sees your health details. An important distinction is between consent for treatment, payment, and healthcare operations, which is generally implied or obtained more broadly, and specific authorization for other disclosures, which requires your explicit written permission. Furthermore, many state laws offer even greater privacy protections than HIPAA, so it is always wise to be aware of the specific regulations in your area. Understanding these rules gives you significant control over your personal health information, ensuring your privacy while also allowing necessary information to be shared for your care or legal processes when appropriate. Knowing your rights regarding authorization is key to navigating the complexities of medical record access and protecting your personal data effectively.